Hey guys, welcome back to the channel. Today, we're diving into part 1 of a courtroom saga featuring a sovereign citizen I've been following for the last few months. What was originally supposed to be a straightforward jury trial back in March quickly turned into a series of hearings packed with bizarre arguments, jurisdiction claims, and plenty of sovereign citizen logic. This first installment covers his earliest appearances, and trust me, things get strange fast. Let's get into it.
Number 4 in the docket, 23 CR 5137 versus Nicholas McKinney.
Holly Sneed for the people. And Your Honor, Mr. McKinney does appear.
Mr. McKinney appearing pro se and
Ringing. Thank you. Okay, so Mr. McKinney appears pro se. He's with his advisory council is also present. Thank you for being here. We're set for a pretrial conference in anticipation of a jury trial that's set for March the 16th. So as to pretrial readiness, is the prosecution prepared to proceed to trial?
Yes, we are.
Mr. McKinney, are you prepared to proceed to trial?
no, Your Honor.
Okay, can you please tell me why?
I have quite a few different issues at the second. First off, I've been denied evidence. Second off, I feel that there's some color of law issues that have presented themselves. Third off, I'm asking that because I've entered motions and asserted that there's still evidence to be presented that I've been denied by, on your behalf, I'm asking that you recuse yourself.
Well, let's talk.
Then I would like to move forward with presenting
Would-
you
would-
with,
would you
here's
please-
my birth certificate of live birth.
Mr. McKinney, we're here for a hearing. You need to let everyone speak. Okay,
Including myself.
correct. And so I'm guiding this hearing, sir. And so the first issue I want you to address is what basis, well, actually, no. If you wish the court to recuse for disqualification for some reason, there's a legal process to do that.
Okay,
And yet you have to follow the rule to do that,
okay.
which is more than just saying, I want you to recuse. You have to follow the rule. And absent a qualifying motion, you don't just do this orally. All right.
I'll
So
file the motion.
So tell me what evidence you feel like you've been deprived of.
I filed, first off, let's start with, I filed a thumb drive with you that was set to be entered in with the court before a certain time frame. I would like to know if that evidence made it into court or not. The first thumb drive.
Well, Mr. McKinney, the court received a thumb drive apparently from you, along with a motion that says motion to enter evidence. That's just not the way things work. If there's evidence to be offered at trial, there's procedures to offer evidence at trial. If there's motions that are filed that require the presentation of evidence, that's a question of laying foundations for the evidence at an appropriate hearing, and then establishing what the evidence is. But just submitting things to the court and saying, I want this as evidence, that's just not a proper procedure.
See, you have an oath of office to protect a sovereign citizen, a United States citizen. Here's my birth certificate. I also have my social security card, Your Honor. Good sir, you are supposed to be protecting me. These people are extorting me. They are committing RICO. They are not allowing me evidence in court. I would like this all on record and for the record, good sir. I am doing everything with the court, including appearing and doing everything I can to stay in good standing with the courts. And in every direction that I have moved, I am being denied evidence. In every direction. By you, good sir, by the defense. Would you allow me to provide service to the prosecution or not?
I don't know what you're asking to do, sir.
I'm asking to provide the evidence that I have that I'm being extorted, the evidence that Holly Sneed and all of the caseworkers and everybody involved in the case are actively colluding together to commit RICO, to deny me my rights, to medically harm me, to medically harm my family, to deny me my rights to my estate, to deny me my rights to my personal and private information, to deny me my intellectual property. I'm being afforded zero representation. I would go as far as to filing Section 18, 241 and 242, and contesting jurisdiction at this stage.
This is one of the most common sovereign citizen tactics you'll ever see. Whenever things aren't going their way, they start claiming that government officials, judges, prosecutors, and law enforcement have violated their civil rights while acting under color of law. The problem is that simply making that claim doesn't magically stop a criminal case. Even if someone genuinely believed their rights had been violated, those allegations would generally be addressed through separate legal proceedings. Instead, he's trying to use those arguments in a courtroom that he's simultaneously claiming has no authority over him. It's a contradiction that sovereign citizens never seem to notice.
Mr. McKinney, you still haven't told me what evidence you feel like you've been denied that will,
It's right here.
well,
There. I have entered in plenty of information. Here, let's go this route, Your Honor. I had court representation, because we're not going to call them defense attorneys. We're not going to call them public defenders. We're going to call them court clerks, because that's what they are. They work for you. You work for me. They do not have an oath of office. You do. You have an oath of office to uphold my rights, and I am being actively denied my rights. And I would like that all on the record, for the record.
okay. So tell me, Mr. McKinney, what is it you need to prepare for trial here? Because we have a trial set March the 6th.
First off, allowed to provide service to the prosecution of what I have. I even filled out with the public defenders paperwork that gave them power of attorney to go and get the medical records from the hospital as evidence. And I firmly believe that first off, they didn't go get that. Second off, I had to have the public defender removed for ineffective counsel. Third off, they haven't presented any of that evidence on my behalf. And I mean, basically at this stage, it's a mistrial. I've had no counsel whatsoever that has been willing to present any evidence on my behalf.
Mr. McKinney, first of all, you waived your right to counsel, so you're your own counsel.
Yeah,
I just want to know.
I had to because of ineffective counsel.
Um,
I would also,
Excuse me. I just don't know what you're talking about, Mr. McKinney.
No, I know you guys don't. You're criminal.
Well, Ms. Sneed, have you provided all of your discovery to Mr. McKinney?
Yes, Your Honor.
I would also like to put on record, Your Honor, just a couple of little short, sweet little terms. I would like the court to figure out if they understand what NALA is, N-A-L-A, okay, or ETC, or a RAD ID, or FFC, or the National Healthcare and Anti-Fraud Association, because I happen to be a National Healthcare and Anti-Fraud investigator. certified in your county.
I'm honestly not sure what point he's trying to make here. The argument is bouncing around so much that it's difficult to follow. But if he's really claiming to be certified in healthcare fraud investigations, whoever handed out that certification might want to schedule a refresher course. Because nothing he's saying right now suggests a strong grasp of legal procedure, courtroom rules, or even basic logic.
If your request is for me to respond to these questions, I decline to do so, Mr. McKinney, because it's not
As
relevant.
long as it's on record, Your Honor.
Excuse me, sir. It's not relevant to these proceedings. We're set for a pretrial conference today, Mr. McKinney, because you're set for a trial in 2 weeks.
Well-
I'm just trying to ascertain.
Then I
what it is-
would,
Excuse me, sir. I'm trying to speak. I'm trying to ascertain what you feel like you've been deprived, what evidence is preventing you from preparing for trial to defend against these charges. That's all I'm asking you, sir.
easy. First off, Your Honor, I've been denied the complete medical records from Denver Health.
So, Ms. Sneed, is there medical records from Denver Health, and have they been disclosed?
Yes, Your Honor, we have disclosed records, all of the records that are from not only the date of offenses, that is approximately 490 pages, while the victim was in the hospital in August of 2023. We have also obtained all of the medical records from birth all the way up until, I'd have to check the last date that we got on the last request we did, is through September 25th of 2025, so 2 years after the date of offense.
Okay.
I would argue that those are tampered with. Dr. Steffi entered the original discovery, and that was a medical assertion, not the medical records, and that the defense has tampered with, or the prosecution has tampered with those, with that evidence. There is not the actual medical record. And I would also argue that there's a conflict of interest because every single one of these people are co-conspirators. They have co-conspired in this same performance for a very long time and know each other extremely well.
Mr. McKinney, you're going down a road here, which is not very productive for you, because none of this is relevant to these proceedings here. You can make these allegations, that's fine, but that's not going to be how this trial is going to proceed. I mean, I'm not going to be letting you make these kind of allegations in open court in front of a jury. And that's one of the perils that you face, apparently, by choosing to waive counsel and proceed in this fashion.
And that's why I'm saying you need to recuse yourself.
Excuse me, sir. And that's not a basis for the court to recuse itself by applying the rules of law here. So I would strongly recommend, sir, that you reconsider your decisions about waiving your right to counsel, because you're going down a path here which you're not going to be allowed to make these kind of assertions in front of a jury. All right?
I have freedom
We're
of
gonna-
speech, Your Honor.
Yes, you do, sir.
Mhm.
And you also are bound by the rules of evidence.
And you're
And it's-
denying me freedom of speech.
Excuse me, sir. You're bound by the rules of evidence and the rules of procedure that govern the laws of this state. And so that's how the trial is going to proceed.
I would just motion for Section 18, 241, and Section 18, 242, and contest jurisdiction if you will not recuse yourself.
That's kind of adorable. He wants the judge removed because the judge isn't helping him build his defense for him. That's not how any of this works. Judges are required to remain neutral. They're not your legal advisor, your investigator, or your personal courtroom coach. Now, interestingly enough, the judge does eventually recuse himself in this case. But that doesn't mean the defendant somehow wins. Judges can step aside for many reasons, and none of those reasons magically erase the charges waiting on the other side.
Well, sir, I've already addressed that. All right. So, Ms. Sneed, what are your thoughts? This trial sounds like it's going to be a train wreck.
Yes, it does.
It's already been a train wreck.
Excuse
You've
me.
abused me.
So,
Your Honor, I guess my concern is, even if we continue this trial, we're going to be in the exact same position at the next court date.
therein lies the problem.
Yes.
Yes.
So,
So we're in agreement. Nobody wants to be good and honorable.
Mr. McKinney, I'm being pretty patient with you, but
I've been pretty patient for 2 years suffering abuse.
so excuse me, sir. So I'm not going to indulge much more of you maligning either the parties involved here or the court. It's not appropriate.
I
all right?
believe this is a
So-
federal problem,
Well,
not a state problem.
then you can go to federal court then, but
Let's do that.
Mr. McKinney, I guess we'll plan to proceed to trial on March the 16th. I'm going to designate just arbitrarily seat number 5 to be the alternate. How long do we expect this trial to require, Ms. Sneed?
4 days, possibly less, but just,
I believe it
Okay.
would take 10
Well,
to peel an onion open full of lies.
I'm going to grant, I'm going to try and get about 60 or maybe 75 jurors to bring down. I think I'll use a questionnaire to identify those jurors we can excuse for cause. I'm thereafter going to authorize 30 minutes per side for voir dire. I want the prosecution to submit the original beyond a reasonable doubt instruction. I'm going to make these proceedings available via WebEx. Mr. McKinney's on bond, so there's no need for a clothing order. My requirements as to the instructions, exhibit list, witness lists are outlined in my pretrial order. And
I would provide the court notice that I'll be going downstairs, filing a motion for you to recuse yourself, filing a motion for section 212 and that I'll be filing a motion for Title 18, section 241 and Title 18, 242, and at this stage, contesting jurisdiction.
This is where sovereign citizen logic really starts folding in on itself. He keeps insisting the court has absolutely no jurisdiction over him whatsoever. Okay, if that's true, then why are you here? If a court truly had no authority over you, you wouldn't spend hearing after hearing arguing with it. Yet somehow, the people who claim courts are powerless over them always seem to show up and spend hours trying to convince the court otherwise.
and just so that you're advised, Mr. McKinney, so what we're going to do is we're going to bring a jury panel down of about 60 to 75 people. I'm going to do an initial introduction of the case to the jury. I'm going to pass out a written questionnaire so the jurors can give their information via questionnaire. We'll give you and Ms. Holly Sneed a chance to review those questionnaires, and then we'll discuss them privately. If there's people that we can excuse by virtue of the questionnaire, we'll do so. Once we've got those questionnaires taken care of, here again, I'm going to authorize each side 30 minutes. We can ask your relevant questions with respect to any potential bias or motives or prejudice on the part of individual jurors. I will advise you, sir, that those questions need to be related to proper issues as to bias or prejudice and not other issues. And if it goes beyond that, I will intervene and stop you. Once you've completed your voir dire, I'm going to have one alternate on the case, which means each side has 6 peremptory challenges. So what we'll do is we'll seat, we'll have 25 jurors. We'll have people in the jury box. The first 13 are the presumptive jurors. So you'll have the seating chart. And seats 1 through 13 will be the presumptive jurors. And so you can exercise your peremptory challenges as to seats 1 through 13. And once someone is excused from that initial 13, the next replacement will be seat number 14 and 15, 16, 17 thereafter until all the peremptories have been exercised. In that fashion, we'll get the jury selected. We will then, after that, the next step will be opening statements. And so each side is allowed to make an opening statement. Opening statement is a statement as to what the evidence you expect to establish. It's not argument. It's purely what you expect the evidence in the case will show. And so I don't impose a time limit for opening statements, although here again, it needs to be relevant and it needs to be a proper opening statement. If it goes beyond that, I will intervene and stop you, stop both sides. Once there's opening statements, and the prosecution will call their witnesses, they'll call a witness, ask their questions. Thereafter, you're entitled to cross-examine those witnesses, ask them questions. And then once you answer your questions, I'll allow the prosecution, or actually the side calling the witness, to do a redirect. In other words, to ask questions raised during the cross-examination. So in that fashion, we'll hear the prosecution's evidence. If you have witnesses to call, they need to be obviously endorsed and disclosed in advance. I'll need a list of the witnesses who,
I have the list here.
well, if they've been endorsed,
I
then you can.
attempted that. I have, here, let's go this route before.
No,
we
excuse me.
proceed.
Let me just explain to you how this is going to unfold, sir.
Well,
So whatever witnesses you've endorsed.
afford me,
Excuse
Your
me,
Honor.
sir. Excuse me, sir. So we'll hear the prosecution's evidence in that fashion. Once the prosecution completes their evidence, then if you have witnesses to call, if you've endorsed them, you can call those witnesses in a like fashion. You can ask them questions. The prosecution is allowed to cross-examine them. And then if there's questions based upon the prosecution's cross-examination, you can do redirect examination. Once that's completed, we will then work on the instructions with the instructions put together. Once the instructions are finalized, and you can obviously tender whatever instructions you feel are appropriate, I'll consider those as well as instructions submitted by the prosecution. Once the instructions are done, I'll then read those instructions to the jury. Thereafter, there'll be closing arguments. The prosecution is allowed to go first, and then you're allowed to make a closing argument on your behalf. And then the prosecution is allowed to make a rebuttal to that closing argument. I will more than likely impose a time limit for those closing arguments, but I'll make that determination during the course of the trial. So that's how the trial is going to proceed.
And under my apologies.
Before we move forward, Your Honor, I have the list here. I would like you to provide me clarification because I keep entering motions with you that you won't accept. So provide me clarification in what you will accept for a legal motion to enter my list of witnesses and my evidence.
No, that's not the judge's responsibility. You made the decision to represent yourself, which means you're responsible for figuring out how to present your own defense. In fact, if the judge started helping you build legal arguments, explain strategy, or tell you what evidence to present, that would create a serious ethical problem. This is exactly why lawyers exist. The legal system can be complicated, and trying to navigate it using internet theories usually doesn't end well.
Mr. McKinney, you filed motions. Those motions, I ruled on those in a written order, which was supplied to both sides. You need to file whatever witnesses, you need to file those with the court so that there's notice from, so the prosecution has them.
I have, and you keep
fine.
denying me.
That's-
Here's the evidence right here.
Sir,
Here's
that's
the
not,
list right here.
well,
I filed a motion. It goes to the clerk of court. The clerk of court brings it to you. You send me a letter in the mailbox. Keep telling me that the legal avenue that I'm proceeding with you is incorrect. So clarify with me what I'm doing wrong so that I can provide you with the proper legal document or procedure in which you would like to see me proceed forward.
well, Mr. McKinney, if you have witnesses that you intend to call, you need to disclose those witnesses to the prosecution in a written pleading filed in court. You've yet to do that, sir. Okay. So this is, we're not going to
So
go back
I
and
need
forth
to
here,
do a
sir.
written pleading right now in court? Or,
Mr. McKinney.
or go down and file it with your clerk of court?
Well, I'll tell you what, and you also have advisory counsel that can help you do those kinds of things, Mr. McKinney. It's not my job to advise you how to do certain things.
But I
Advisory
already
counsel.
had that and already filed with you before and am being denied what I am filing with you.
Well, that's not accurate. I've got the file in front of me. So I think we've done as much as we can do here. We'll do our best to get the case to
Before
the
we
jury.
wrap up,
Yeah.
I have been in this case for 2 years, believe that we are past speedy trial. And if you do not believe that we are past speedy trial, in the fashion that these two court cases, civil and felony, have preceded themselves, I would motion for reclamation of time, to reclaim my time.
Okay.
Because this should be said and done and over with, because I entered a plea of not guilty a long time ago. You guys paused the clock. If you're pausing the clock and I have ineffective counsel and I have to do a burger's case to get rid of the ineffective counsel, then I seek to reclaim time.
File a motion, Mr. McKinney.
Okay.
Thanks.
Your Honor, just a clarification, the alternate seat number, I apologize, was it 5?
It's 5.
Thank you.
All right. Okay. Thank you.
Also show you, these are my social security cards for Sarah and William McKinney and myself, which are part of my estate and my intellectual property. Good, sir.
That may be one of the funniest lines of the hearing. You need intellect before you can claim intellectual property. With that, we reach the end of his first appearance, or at least the first one I was able to find in my archive. And despite all the arguments, motions, and jurisdiction challenges, the case keeps moving forward. The judge ultimately recuses himself, which means the next hearing will take place in front of a completely different judge. Spoiler alert, the sovereign citizen arguments don't improve.
Right, this is 23 CR 5137, People versus Nicholas McKinney.
Good morning, Your Honor. Holly Sneed and Meredith D'Angelo for the people.
Good morning, Judge Ashley Whittam as advisory counsel for Mr. McKinney, who is present.
Mr. McKinney, pro se, Your Honor.
All right, good morning, everyone. All right, this case is new to me. It's my understanding it was originally in 5B, and then Judge Egelhoff issued an order recusing, and then the matter was reassigned to me on Friday, I believe.
Yes.
I also understand we're set for trial today.
Yes, there is a request by the people. I did file that last week, but I know Your Honor is new to this case. The people are requesting a continuance of that trial. I have spoken with Ms. Whittam, who has spoken with Mr. McKinney. He is not objecting to that continuance. And we have pre-cleared a date with the clerks as well, if it works for Your Honor.
Oh, okay. That's all correct, Mr. McKinney?
Yes, Your Honor.
Okay. What dates did you pre-clear?
The week of, I believe this is a Tuesday start courtroom, so it would be the starting on July 14th.
What's speedy?
Right now, Your Honor, speedy is May 1st. However, if the court agrees, it is the people's position that this would extend speedy trial by 6 months due to the unavailability of a witness who will be available at that later date, and that is under 18-1-405 6GI, or 6G Roman numeral 1. To be tried within speed.
So, all right, let me just say that, Mr. McKinney, you're agreeing, as I understand, the motion to continue is there's an essential witness that's unavailable by the people.
Yes, that is correct.
Mr. McKinney, you're not contesting the fact that this is an essential witness that is unavailable. Is that accurate?
I have no idea, Your Honor. I haven't even been presented with this witness or this information until now.
Okay, the motion to continue was filed, March 11. Did you not see that?
No.
And so I spoke to him this morning about it. It sounds like he hasn't got the actual copy yet in the mail since he receives the filings via mail. So I made him aware of it this morning, but he hasn't received the filing just based on the mail. But I've showed him.
But so I guess I first need to know whether you're contesting that this is an essential witness, because the premise of the motion is that they're requesting a continuance because an essential witness is unavailable. That finding of an essential witness is going to be important in order to make findings on speedy later. So I need to kind of take it step by step. Do you need a moment to look at the motion?
Yeah,
Will you
if we
pass the
could real
matter?
quick.
It's fine. I can pull it back up, Judge, and we can recall this if we can just.
Let's do that.
Sorry, Your Honor.
No, you're fine.
So the court pauses proceedings to give him an opportunity to consult with advisory counsel and verify whether the unavailable witness is actually essential to his case. And honestly, this is the part I always find ironic. Sovereign citizens constantly argue that courts are violating their rights, denying them due process, and refusing to follow the law. Meanwhile, the court is bending over backward to make sure every procedural protection is respected and every constitutional right is preserved. It's hard to argue your rights are being ignored while the court is actively taking extra steps to protect them.
All right, we're recalling number 28 in the docket, 23 CR 5137, People versus Nicholas McKinney.
And Holly Sneed for the people.
Ashley Whittam as advisory counsel for Mr. McKinney, who is present.
Mr. McKinney, pro se.
All right. All right, did y'all have a chance to talk?
Yes.
Yes, Judge, and I've showed him the motion again. I believe that he agrees that it would be an essential witness.
Is that accurate?
Yes, Your Honor.
Okay. Court grants the people's motion to continue the jury trial. The jury trial is set to begin today is vacated. I'll find that the continuance is granted based on the people's motion and a missing missing essential witness is unavailable. The parties have agreed to resetting. I'm wondering, it was set for 5 days, is that right?
I think 4 is safe.
Okay.
Understanding this is a Tuesday start and there's no, limitation on how long the jury can deliberate. I think the testimony can be completed in 4.
Okay. Do you agree, Mr. McKinney?
I would think it would be a little bit longer to peel open an onion.
Do you think 5 days is more appropriate?
I think maybe more along the lines of 6. I believe there's going to be quite a bit of testimony and stuff by the time this gets peeled open. There's a lot here to unpack.
Okay. Well, I do normally have, it's a Tuesday start and my hesitation is it's the following week. I may need to be leaving on that next Wednesday. So I'm wondering if it makes sense to just go ahead and do a Monday start and set it for 5 days.
That if we can accommodate the 13th, that works for the people.
We can also accept
Would that work for you?
Yes, Your Honor, that works for me.
Okay, and for you as well, everybody works?
Yes.
Okay. Why don't we go ahead and do that? We'll set it for a 5-day jury trial, scheduled to begin July 13. How many were requested for today?
I know Judge Egelhoff was planning to do a questionnaire, and I think we have 65. Whether it's a standard. Yeah, 60 to 75. I think that still would work. Maybe closer to 75 if possible, just based on the nature of the charges. I think the questionnaire will probably knock out a good portion.
I would agree with that, Your Honor.
Okay, 75 jurors. Did Judge Egelhoff have a questionnaire? Did you all work on one?
He has at least a standard questionnaire I know he uses in sex assault cases. I assume it would be the same one, but I'm happy to confer with Mr. McKinney and Ms. Whittam. I have one that I think we could submit to the court, or if the court has one that you prefer to use, I'm happy to. Yeah.
I don't have a standard one, so I generally ask the parties to try and confer, and if they can file one jointly, that's great. I'll review it. I do ask you try and keep it, I'm going to ask that you keep it to one page.
Yes.
The other thing I do ask.
Sorry, I was just explaining to him how the questionnaire process works.
Yeah, that works.
So that he
Sorry, Your Honor.
understands.
That's okay. I do ask, whatever format you use, that it includes at the top right, a place for jurors to put their cell phone numbers and their seat number. So it's just a little added thing. And that way it just saves us a step in trying to get them from the jurors. So if you could just include that on whatever proposed questionnaire you have.
I can send that over to Ms. Whittem today, and then that should hopefully give plenty of time to speak with Mr. McKinney and make any adjustments
Okay, perfect.
before July.
And so did I hear previously the parties agree that based on the finding of the unavailable witness, that speedy trial would begin anew today, 6 months from today? The parties agree?
Yes.
Yes, and could I get that date?
Yes, so I will set, based on that record, the parties agree speedy trial is now September 14. Normally, I would just set a pretrial conference at this point, but because the case is new to me, I'm going to ask you, do we need an intervening date set for any issues?
We might want to do that, Your Honor, just in case.
That's
Okay,
fine with the people.
so I'm going to defer setting a pretrial conference, and we'll just set we'll just call it a status date to see if anyone has any issues that need to be addressed. Does that work?
That works for the people.
How about, does May 1 work?
If that works for you, I believe that'll work for me.
Judge, I'm out of the country, but I could appear virtually.
And I'd be fine with that.
If that's what you want to do, or we can look for another date.
That's fine. That works.
I'm fine to appear
Yeah,
virtually.
we're fine with that.
That works for the people.
All right, I'm going to set the matter for status conference May 1. If the parties anticipate needing to address any issues, if you could just file something letting me know what issues may need to be addressed, even if it's just some sort of notice. Otherwise, if there are motions that are filed, we'll plan to address those at that time. Okay, bonds continued until all of those dates and times. Is there anything further?
Not from the people.
Nope, Your Honor, we're good.
Okay, we'll see everyone then.
Thank you, Your Honor.
And that's where we'll leave things for today. These were only the first couple of hearings, and we're still a long way from the jury trial that our sovereign citizen insists is happening in a court that supposedly has no jurisdiction over him. There are plenty more appearances to cover, and the arguments only get more interesting from here. I'll be bringing you the next installment either later this week or early next week, so keep an eye out for that. If you enjoyed the video, leave a like. If you didn't, feel free to hit dislike. Either way, let me know what you think in the comments, and don't forget to subscribe with notifications turned on so you don't miss the next chapter of this courtroom adventure.